Good afternoon if you're on the East Coast, and good morning to those way out west. My name is Scott Goldschmidt, and you're listening to Grants in Higher Education, a primer in recent topics, which is part of the higher education webinar series offered by the law firm Thompson Coburn. Thompson Coburn, if you don't know us, is a national law firm with offices across the country. And interesting for this presentation, we have both a higher education and a contracts and grants practice within the firm. And for the higher education practice, it means we have a group of individuals who spend most or all their time serving institutions of higher education. While folks are jumping on, I want to take a quick second to apologize for our technical difficulties on Tuesday. The presenters were all set to go, but unfortunately technology had other ideas. We appreciate you sticking with us and making the time to join us, especially on a Friday afternoon. A lot of important things to talk about. First things first, we got to get through some housekeeping. So if you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We're going to try and answer all your questions following the presentation, but if a more complete answer is needed or we run out of time, you are most welcome to connect with us directly via email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links you may find helpful. You can also find additional answers to some common technical questions located in the help widget at the bottom of your screen. If you experience technical problems during the webinar, those can be reported through the Q&A widget. Today's presentation, as most higher ed presentations are, is CLE accredited. For attorneys for CLE credit, this presentation is accredited in California, Illinois, and Texas for 1.5 hours of general credit, in Missouri for 1.8 hours of general credit, and in New York for 1.5 hours of professional practice credit for experienced and transitional attorneys. We award CLE credit based on attendance for the entire 90 minutes of the presentation. As required, we'll display secret words in 3 multiple choice polls during the presentation and some secret facts about some of our presenters too. You're going to be required to select today's secret word from a multiple choice list. Please respond to these polls to demonstrate your continued engagement and earn CLE credit. We value your opinion and appreciate your participation in the course. All right, to our preamble. Our disclaimer here is more relevant than ever, right? Laws and policies are updated regularly. Litigation is fluid. Just between the Tuesday to Friday delay here, we were updating slides. As you've been following the news, things have happened. If you're reviewing these slides after April 11th in the afternoon, please keep in mind changes may have already occurred. We hope we're staying current, but we're going to keep on it just for everyone to keep in mind. These things are updated regularly. This is a really fast-moving topic. The hyperlinks in these slides, including the PDFs, are active. If you have any interest in the underlying materials, please click on the slides to go to those resources. Thompson Coburn, the higher education practice, we have a ton of free materials available for institutions, practitioners, the higher education community. Those resources, the rest of the presentation and at the end of the presentation can be accessed by clicking the Here button in the 3rd column or scanning our new magical QR code in the 4th. One of our new really exciting resources put out by Brent and his colleagues is a higher education litigation summary. If you're having trouble following higher education litigation, I certainly commend you to go look at that. It has everything in one place. It's going to be updated on a bi-weekly or monthly basis. Please feel free to check that out. That brings us to our presenters. I'm delighted to be joined by 3 outstanding colleagues at Thompson Coburn presenting this webinar. So Camille and Jana work with me out of our Washington, D.C. office. They practice in our government contracts group. But as you might expect, their work with institutions of higher education is taking more and more of their time recently, and we're considering making them honorary members of our higher ed group. So Camille's an associate in the practice. She just started working with us recently. We're delighted she's joined us. She came from a boutique government contracts firm. Before that, clerking for the Civilian Board of Contract Appeals and interning at the Court of Federal Claims. She advises clients on government contract matters, including claims, bid protests, employment, and compliance issues, as advises clients on grants, law, and compliance. Jana Russ, my colleague, is a partner at Thompson Coburn. She advises clients on doing business with or receiving federal financial assistance from the federal government and represents them in litigation against and with or on contract disputes and bid protests. Prior to joining Thompson Coburn, Jana interned at the U.S. Court of Federal Claims and the Appellate Court for the Court of Federal Claims. Brent Hill is in our higher education practice. He works out of our Birmingham office, which just celebrated its 1-year anniversary at the firm. So congrats to our Birmingham office. Brent and the Birmingham team are litigators, higher ed litigators, which means they spend their time representing educational institutions in student and employment litigation and arbitration. Love having Brent and his colleagues at the firm, along with being just great people. I get to send Brent and his team all my difficult litigation questions, so it really works out well for me. Brent represents education institutions primarily in student and employee litigation and discrimination cases brought under Title VI, Title VII, and under the ADA, as well as breach of contract and tort cases. He also represents schools in disputes with state licensing boards and crediting agencies, helps with government investigation, and has developed a niche practice defending institutions on TCPA, Telephone Consumer Protection Act matters. As I mentioned, my name is Scott Goldschmidt. I'm a higher ed regulatory attorney based in our DC office. Prior to coming to DC, I spent a better part of a decade in-house in the general counsel's office at Catholic University in Washington, DC. Pertinent to our presentation here, and maybe you're not aware, Catholic is a significant research institution and just achieved R1 status. So belated congratulations to Catholic University. Very apropos for our presentation. All right, now on to our syllabus. See what we did there, syllabus. We're happy you're all with us. Looking at the attendee list, we can tell we have attendees with a wide range of experience with federal grants, from smaller schools or community colleges we work with that maybe have a WIOA grant to schools with multi-million, billion-dollar grant portfolios, right? So because of this wide range, we tried to be deliberate in putting together the presentation. We promise we're going to take care of all of you, be it those with little experience or those with a lot. So we're going to start with the basics, some foundational concepts that might be new to a lot of you, may be review for others. Hopefully that's helpful. For those with a lot of experience in grants and contracts, hang with us. Hopefully the review is helpful. After that, we're going to switch gears to more complex topics and address the current news, developments in litigation, and all the fun that goes with it. All right, and so with that, I'm going to start off with a really brief high-level overview before I kick it to Camille of federal grants at institutions of higher education, right? So basics, I'm going to start here. Federal grants are funds provided by the U.S. government to support students, institutions, and research initiatives in higher education. Right? Important to know, and this should not be news to anyone on the call, grants come with reporting and compliance requirements, right? The government is spending this money. The purpose is to ensure the funds are being used for their intended purpose. They require compliance with federal regulations, such as CFR Part 200, or 2 CFR Part 200, excuse me, or 45 CFR Part 75, various non-discrimination laws, financial management standards, and research integrity rules. They also require recipients to meet benchmarks to ensure the federal investments are leading to measurable benefits to education and society. Non-compliance, right, as we're learning in the news with grants, may be severe. And we're going to really get into that a little later in these details, right? So when we're talking about grants, what are we talking about here? So a couple different kind of broad categories to level set. So financial aid, we usually think about direct loan program, work study program. That's not what we're talking about here. That's part of Title IV, but there are financial aid grants that are worth mentioning. For example, Pell Grants, right in the name, or FSEOG, or Federal Supplemental Educational Opportunity grants. There's also workforce development grants. So specifically, we work with a lot of institutions with WIOA grants. If you're not aware, WIOA helps job seekers access employment, education, training, and support services, and provides federal funding to states and local workforce boards to implement training and employment services. There's also institutional and programmatic grants, right? These are used to support colleges and universities developing programs, improving facilities, or increasing access to education, right? In particular, Title III and Title V of the Higher Education Act grants for MSIs, HSIs, and TRIO programs, right? That's meant to assist first-generation students, disadvantaged students attending institutions of higher education for the first time. Finally, a lot of the grants we're hearing in the news and we talk about are research grants, right? So research grants can be from a lot of different federal agencies, and basically they're meant to provide support for scientific funding, innovation, institutional improvement, and kind of programs that specialize in those services. So most we see NIH, National Institutes of Health, Department of Energy, a lot of agencies, Department of Justice, kind of have these grants. And finally, just a level set on kind of campus structures. So, I mean, as we learned during the HERF challenges over the past 5 years, some institutions kind of getting this money for the first time never heard of CFR, 2 CFR Part 200. This is all a new process to them. Others, it's kind of second nature, right? So for institutions that have never heard of it, this is all going to be a little bit new. For those with established grant offices, right, sometimes they're called sponsored program offices or research administration offices. The structures at these institutions vary, right? Sometimes institutions will have a single office that manages grant administration for the entire university, regardless of specialty and agency. Sometimes the grant administrators are embedded within colleges or departments, and sometimes there's a hybrid structure that combines elements of the centralized and decentralized structures. But probably no institution does it the same way, but it's important to kind of have those at the outset. All right, I promised I was going to be quick. With that, I'm going to turn it over to Camille for Grants 101.
Okay. Thanks, Scott, and hello, everyone. So I'm Camille, and I'm going to be going over a really quick preview of Grants 101 with Jana, and we'll be going back and forth on this section. And so let's begin. All right, so life cycle. I'm going to start talking about the grant life cycle, starting from how grants are authorized and appropriated, and then going down to like you finish your grant program, everything's all the performance, and we're closing out. And so many of you are probably familiar with starting off with a notice of funding opportunity. And while that's sort of the beginning for a lot of grant recipients and subrecipients, the actual life cycle grant begins far before that. And so usually we all sort of know a little bit about how the legislative process works, and the Congress goes, so submits a bill and passes through. And this is usually how grant programs are. These are how grant programs are authorized. They're authorized through a statute, and this is what we call the authorization of it. Congress then appropriates funds for those grant programs to then have funding. And the way this works is that Congress will authorize a grant in one statute, but then sometimes they may decide, okay, we're going to appropriate the funds and say, agency, you can now have X amount of money to run the grant program. They might get in the same statute. Oftentimes, still, they'll appropriate the funds in a second statute or through annual appropriation bills for like multi-year grant programs. Really important, especially in the last couple of months, are just understanding like if an authorization operations are mandatory or discretionary. For example, Congress can go and say, okay, agency, you must use this funding for these specific purposes for this grant program. Or the Congress can go and write a statute that says, here's a general policy that we want them to go through for the grant program. Agency, you decide how this is going to actually play out. So it's a discretionary authorization. This distinction is going to be a factor in a lot of court cases we predict, challenging an agency's ability to terminate a grant and not award the funds to another entity. So Congress has authorized the grant program. There's funding for it. The executive branch will then issue executive orders, memorandums, or other guidance to implement the statute. This will then direct the agencies to develop policies to actually implement the grant program. At this stage, agencies will then go and actually plan out the grant program. And this includes identifying the objectives, the goals, the priorities for each funding opportunity. They also have to determine at this stage the eligibility criteria for the grantees if it's not already in the statute. The evaluation criteria, so they can fairly evaluate applications that they receive, and the award criteria for the award grants. At this point, some agencies will engage industry or potential grantees to help shape these funding opportunities. Okay, so we have the grant programs authorized. We have funding for the grant program, and now the agency is going to issue its notice of funding opportunity, which is usually on grants.gov. And this is the point where you all will start participating in this process, this life cycle. So the notice of funding opportunity is usually open for at least 60 days. It can be less than 60 days, but should be at least for 30 days unless there's some reason for it. The notice of funding opportunity is going to contain all necessary information for applicants to apply for the funding opportunity. So this is going to include the criteria for eligibility, the key dates, the total amount of funding expected, the number of awards the agency expects to give out, and the goals and objectives of the program. And this is really important for applicants to really review the stated criteria for eligibility and evaluation, making sure that your application proposal aligns with the goals and objectives of that specific program. Something else that applicants should also be aware of is the SAM registration. So this is for anyone unfamiliar, is a system for award management. Basically, you register your company there for federal assistance, and the agency sort of checks this to review records for responsibility qualification, which we'll explain what that means further down in the presentation. Okay, so agency now has everyone's proposals and applications, and the agency is now going to select applications for award. And usually it is through a merit review process where they look at the technical criteria or technical parts of the applications and compare it to the objectives and the goals of their program. The agency also at this point conducts a risk assessment, and then this can also be a competitive process. Sometimes the agency will engage industry and ask to create a peer panel review, and then we'll use those people to review the applications coming in. Agency will also conduct a financial review of the budgets to ensure that the budget that you're submitting is reasonable. And so you want to make sure that as you are creating a proposal that you are considering how costs are going to be spent if you receive the award. So the agency has done this review, it's reviewed the budgets for reasonableness, and now it is going to issue an award. However, before they do issue that reward, they want to finalize it. So they first issue a notice of award, which is basically an offer to finalize the award and contains the terms and conditions that are going to be in that final award. A lot of these items are usually up for negotiation, which is very different from the procurement process, where in a procurement process, by the time you get to the award stage, it's whatever's in the award is what you're going to get. And agencies, however, do not like to tell recipients that a lot of these are negotiable, and they often do not like to negotiate these items. However, it's really, really important for everyone when you get the notice of award to really review the terms and conditions, to really understand what obligations you're going to have under your award. What is the performance going to look like? How are you going to get paid? How are you going to close out the award? All of those things you're going to have in the notice of award, and you're going to want to make sure you review it. And if there's any issues, or you imagine or predict there's any issues, you might want to consult with your legal counsel to figure out what are the regulations for it, but then also raise it with the agency at this point, because it's at this point, before they finalize the award, that they might be able to change things or speak the truth with you. So now you've finished negotiations. Hopefully you're able to get an award that works for you and works for the agency. You're performing the award. And so as you're performing the award and the grant activities, there are a couple of things that you will want to keep in mind. One, you'll have to draw down funds and perform the activities. And so this usually is where it's really important that you understand how the payment procedures work in your award, and they're going to all be very specific to your award, even though there's general guidance for it. You also going to have to understand the agency policies for drawing down funds. Usually the process works that sub-recipients that you have are going to submit invoices, quarterly is common, to the grantee, and then the grantee will then submit its own invoices and the sub-recipient invoices to the agency. The agency reviews it all, and if they approve, then you can draw down funds from the allotted funding. You're going to also have to be really well aware of the obligations and compliance. If Scott mentioned this at the beginning, and compliance is very, very important, especially in the last couple of months when agencies now are reviewing all the grants and the programs they have going on. And so we're going to talk a lot more later about the obligations and compliance requirements. Reports are really important, and you want to make sure that you are submitting the reports depending on your award and sub-award documents. Usually these are going to be financial and performance reports. Further, grants have audits, and you want to make sure that you know when and how you are going to be audited, making sure you have all the records and documentation that you should be keeping track of as you're performing the grants. Okay, so the grant's done well. Hopefully everyone's been able to achieve whatever objective or goal they were trying to achieve with this grant, and it's time to close out the process. And so the closeout process is basically the federal awarding agency, the pass-through entity, determines that all the applicable administrative requirements and required work of the federal award has been completed. And then they take steps to close out that grant. And this is usually going to require, one, the submission of all the required reports. And this is usually should be all submitted within 120 days after you finish performing the grant. And then the liquidation of financial obligations. So you want to make sure that your subrecipients have submitted all their invoices to you and that you've submitted your invoices along with subrecipients to the agency, that the agency has reviewed them all, and that all the money has been drawn down as necessary. This is really important because you do not want to delay payments on any of this because there can be consequences for that. Additionally, even though your grant has finished and you no longer have any obligations to the agency, you do have to keep records. So you want to make sure you understand what your record retention policies are and requirements, because this can cause issues down the way. The agency says, hey, we want to reevaluate this or look at these records. Please show us your documentation. You need to be able to have those available. And now I'm going to pass it on to the fun world of grant budgets to Jana.
Thanks, Camille. And I saw that there was a question about whether or not the slides are available for download. They are in the resource widget, I believe. So let us know if you can't access them there, but that's where I believe they are. And I know there was another question that came in about pre-award compliance check. We'll hope to answer that towards the end. I think it'll fit in a little bit with some of our later topics. But hopefully what folks heard from Camille's side was that what you're hearing here isn't really just higher ed law that's coming into play on grants. It's this body of grants law and regulations and requirements that end up, taking us through the grant cycle. But also what kicks us off is appropriations and fiscal law, which is also a whole other area of law that sometimes I think folks who receive money from the federal government don't always think about or understand. And it's an incredibly complex process and something that I would dare say even a lot of government contracts and federal grants attorneys don't fully understand because it is so unique to just the early part of the life cycle. But it is something that is, I think, going to be very relevant to how some of these the grant litigation plays out, but also just how grants are performed and what grant recipients must do, because all of this comes down to money. And that's why this slide here is about grant budgets. And this really here is about things that in-house counsel and administrators should understand when it comes to budgets. That's what I tried to put on this slide. I'm not going to read it through for you, but really this is an area that I find a lot of C-suite level and in-house counsel like to avoid because they think it's something the program team needs to pay attention to or only the finance team needs to pay attention to. But when I talk with clients who receive federal grants, I always encourage the general counsel's office or attorneys in-house to have some really good understanding of the budgets that their teams are putting together. And same for C-suite folks. Now that you have to understand every line item, but you need to have an idea of what it is that your program people are asking for. And part of that is because what the government pays for, it usually has some kind of an interest in. And this is going to be significant implications for property that's acquired or developed under a grant. That's going to be significant for some folks. That might be equipment. I know whenever Scott and I have worked together on previous grants, folks may be purchasing equipment to help train future employees for workforce development. So equipment that is used to train electricians, those kinds of things. But others may be really concerned about intellectual property. Here, you really need to make sure you understand what the government's interest is in any intellectual property that's developed under a grant. And you can only have a true understanding of that if you know what the government is paying for, which comes in through the budget. Another area that is really important to keep in mind is indirect cost rates. This is an area in the grant budget that I think a lot of folks had overlooked before. I do think and I know Brant's going to talk about this a bit later, the NIH reduction of the indirect cost rates from negotiated rates down to essentially the de minimis rate. That can be a huge impact on a school, but also when you have an indirect cost rate, generally there's various differences in compliance and record keeping. And so folks need to understand that side so that they can have internal controls and so that they can review internal controls to make sure that they're comfortable with the levels of risk that the grants team is taking, because the attorneys in-house and C-suite level folks at universities or colleges really need to be familiar with these concepts so that they can be comfortable with risks that the grants team or program team might be taking. And part of this is because the program team, including any faculty who are preparing budgets as the PIs for research grants, they may not fully understand recoverable compliance costs, because in a lot of instances, compliance costs can be wrapped into grant budgets, but they're not thinking about doing that. They're thinking about really the performance side. So when you think about Camille's previous slide, they're thinking really about how can we perform and meet the goals of the grant. They're not necessarily thinking about how can we make sure that we have audit costs covered. How can we make sure that we have appropriate legal services covered, either as direct or indirect. Those are things that in-house and C-suite level folks are going to be thinking about, or should be thinking about, and can only recover if it's addressed appropriately under the grant budgets. And the other thing is to keep in mind is that oftentimes legal is only brought in to review at the award stage, and oftentimes that is too late to negotiate some of these items, because again, remember that from Camille's slide that some of these items are negotiable. So to the extent legal can be involved at the proposal stage and understand what is happening there, they may be able to review some of these things and catch some problems with property interests, with indirect cost rate interests, and the risks involved with various issues in the budget. But it might be too late if it's just once the program team has negotiated the award. So that would be one of the things that I would say I generally counsel folks on, is making sure that you have that lined up. The next thing I'll talk about, this can go pretty quickly. It's what's really required from a compliance side. And this is generally speaking, as Scott mentioned, there's a number of things that you have to do to comply, but the main obligations under 2 CFR Part 200 and 45 CFR Part 75 are these subparts that are listed here. And for those who aren't familiar with the two parts that I'm talking about there, Part 200 versus Part 75, Part 200 is what's called the Uniform Grant Guidance, or used to be called that. It has a much longer name now, but it's still, I think, colloquially referred to as Uniform Grant Guidance, and it applies to most agencies. 45 CFR Part 75 applies to Department of Health and Human Services. So anybody who has research grants that's covered by Health and Human Services, which includes NIH, SAMHSA, a number of other of those acronyms that sound unfamiliar to many of you, but also very familiar to some of you. Those are different sets of regulations, very similar, but there are some key differences. Under both of them, though, they have the same topics that they cover, which includes those listed here. And these are in subpart D of the post-federal award requirements. There's 4 that I'm going to call out specifically just because of the risks of non-compliance for schools. The property standards is one. As I mentioned earlier, there's government interest in various property, and this can give rise to disputes later, and it can also give rise to audit findings. So it's an area that schools want to make sure that they are very familiar with as they look at how they need to comply with these parts. Procurement standards is another one. This is one of the biggest issues in reviews and audits. And it's very easy for the auditors to find issues because it's documents, and it's very easy for findings to arise there. Another problem that often arises is subrecipient monitoring and management. This is often something that is a focus of reviews and audits, and it's an area that is often unfamiliar to attorneys and C-suite folks who are unfamiliar with federal grants. And this is something that we see coming up oftentimes, is this concept of subrecipient monitoring and management. And what a subrecipient is a foreign concept for a lot of folks. The last thing I'll mention as far as a compliance obligation here is the cost principles. This has a couple of topics that can be really problematic for schools. Time and effort reporting is probably the main complaint I hear from grant recipients, or I should say schools who receive grants. It is oftentimes a nightmare for schools to track this. And it's also a very easy area for the Department of Justice or offices of Inspector General to come after schools for violations. We've seen some very high profile cases where there have been issues related to time and effort reporting, and rightfully so, that then increases schools' concerns about how they're tracking the time and effort of their investigators, their principal investigators for research, or others who are performing on their grants. But then also recoverable activities. What activities can be recovered by federal funds? So with that, I'll turn it over to Camille to talk a little bit about some of these other things that have come up so far.
Okay. Thanks, Jana. And yeah, so as Jana was explaining, subrecipient monitoring and management can be very difficult, especially since you have to first figure out who of the entities that you're contracting with as a recipient is a subrecipient. And so the 2 CFR talks about the subrecipient is someone who receives a sub-award from a pass-through entity to carry out part of a federal award. Doesn't really give us much there. So there are 2 different types of entities that we have to sort of distinguish from a subrecipient. The first ones are beneficiaries or participants. So the subrecipient is it's a person who has a sub-award. And the sub-award is a contract and legal document. So that means that they have a contract with the recipient. I'm going to give some examples because it's a little bit easier to understand that way. So for example, you have a college who's receiving a workforce grant, and the state is maybe considered the pass-through entity. The subrecipient would be the educational institution or the college. In other cases, let's say you have a nonprofit that does research, or who supports research, they might be the one receiving the grant. So they're the one who went through the proposal stage, negotiations with the agencies to get the grant. They will then award a sub-award to the school for doing research. And so the sub-award is this contract legal document between the grantee and the sub-recipient. And this is going to include how the payments are made, the obligations for each party, the reports that the sub-recipient will make to the grantee. This is a really important document to have because it will also flow down the requirements from the grantee's grant to the agency. So you're going to really have to make sure that you understand what your obligations are as a subrecipient by not only understanding the sub-award that you have, but also what is the grantee's grant. So once you have that sub-award, that's usually a really good indication if you're a subrecipient. Beneficiaries or participants are people who are, as you can imagine, benefiting from the grant award. So another example, suppose there's a grant to help non-traditional students attend college. And so the college is going to be the subrecipient, and they have a sub-award from, let's say, a pass-through entity, which is the state. And they decide to use those funds for daycare to support non-traditional students because they did some research and found out that a lot of the non-traditional students were struggling to attend classes because there were mothers that needed daycare. So the students who receive the daycare benefit funded by that grant are going to be the participants or the beneficiaries of the grant award. And again, the college is then going to be the subrecipient, the one who has all the obligations and requirements to comply with a sub-award and then also comply with the grantee's grant with the agency. Another entity or group that you have to distinguish subrecipients from are contractors. Subrecipients are not contractors. And this is going to be very important to distinguish between the subrecipient and a contractor because it's going to affect what requirements and how you procure the services of contractor versus awarding a sub-award to a subrecipient. So contractors are those that, as you can imagine, are hired specifically to provide services or products to a grantee or subrecipient. And this determination is going to turn a lot about what the grant is for. So you're going to have to look really closely as to whatever the grant is for. For example, if a school had a research grant to study potential cancer treatments, the school might then, school being the subrecipient or the grantee, would then have to procure specialized speakers or test tubes for the research, the company they're procuring these specialized beakers or test tubes from is going to be considered the contractor. This is really important because the requirements for a subrecipient versus a contractor are very different. If you're awarding to a contractor, you have to follow, and Jana talked about this before, the procurement standards that are really difficult to understand, and each recipient must have procurement standards for it. And so usually this requires full and open competition and specific procurement procedures, what I'm more familiar with from my government contracting aspects there, compared to subrecipients who have to follow the requirements and compliance obligations under 2 CFR and the award documents. Further on, this also affects how the recipients choose subrecipients. It doesn't necessarily have to be full and open. This is also going to affect what terms are included in the award, so how payments are made and whatever entity can make profits. Contractors can make profits, sub-awardees cannot make profits. Okay. So that's very quick background as to how to say a subrecipient. Please, you would probably want to consult your legal counsel and look really closely at the grant documentation to sort of figure out whatever the person you're working with is a subrecipient or a contractor. So we're going to move on now to requirements for compliance. And again, this is one that we're going to have to look really closely at the grant award and the sub-award documents to see what it is that you're agreeing to comply with. So generally, what is in the funding opportunity announcement, what's in the application proposal, what are in your award documentations. There's going to be federal regulations. There are going to be statutes you have to follow. There's going to be requirements that are incorporated by reference. All of these things are going to make up the regulatory body that you're going to have to comply with, or the contractual body you're going to have to comply with while performing a contract. And Jada talked a lot about this. A lot of this is going to really focus on money, how it's being used, how it's being spent in the contract, in the grant, sorry. All right. I'm going to refocus on this. So another part of body that you're going to look for to figure out the requirements for compliance is that you're also going to look at the agency guidance. So for example, the National Institute of Health has a grants policy statement, which is often incorporated by reference, and you'll want to review that to just sort of understand what it is that you're agreeing to do. Really important, the grant making agency oversees the compliance of the grantee and the grantee. So if you're a university, you have subrecipients, you're responsible for overseeing the compliance of your subrecipients. And this is generally going to be reviewed through those reports that you submit as a grantee or subrecipient. And the focus of these are usually going to be on financial performance or pragmatic aspects of the program. And now I'm going to turn it over to Jana. Talk about what happens if you're not compliant.
Yeah, and a couple of other things that I wanted to put on folks' radar of other requirements that may indirectly apply that I think sometimes in-house attorneys and C-suite folks think about later in the process are FOIA obligations. So keeping in mind what the federal government may release in any of your proposals or communications with the agency. Also for a number of the higher ed space, for those of you who are considered state or local entities, you may be subject to state FOIA obligations as well. So that's going to play into how you mark various things as far as confidentiality. But also there's appropriations requirements that may come into play that aren't ever referenced in regulations, but that may prohibit the federal government from giving you money, as well as some research obligations that could come in as far as research misconduct. There's research requirements for human subjects. There's research requirements for animals and animal research. So there's all of these other things that folks need to make sure that they're aware of and considering how they play out. But another one that I think has come up a lot in the last 4 to 5 years, and it's been something we saw increase just generally in that time period and across administrations, is the concern about foreign nationals and foreign access to research. A lot of schools are struggling with dealing with this HR issue because there may be a number of master's level students that are helping with research that are from countries that the U.S. really does not want to have access to various research information. And so these are all things that schools may have to keep in mind as they think about compliance. Because what happens if there's non-compliance? There's a number of things that could happen. These are all up here, and really, there's the spectrum of what could happen varies from just a hassle and having to have more oversight and more bothers for the folks performing, which is, the conditions on award and more oversight, or responding to agency subpoenas and things like that, to the loss of funds. So it could be the loss of the award itself. It could be the loss of all federal awards, or it could be the loss of the ability to go after future funds, which would be the suspension and debarment. But also prosecution is a fair possibility in some very severe cases for those involved with this. And we have seen that happen with a number of research universities where the folks involved were prosecuted for noncompliance, because it's not just noncompliance, it's to the level of what's considered fraud. I say research universities because that's where we've seen Department of Justice previously and prior to all the things we're hearing in the news go after some institutions of higher education. But there are other instances where there may be fraud happening at smaller schools, just even in what they're conveying in the grant applications, or whether or not they're eligible for certain things. So there are these risks of noncompliance across the board. I think they're probably higher for the research institutions, for some of the reasons we talked about earlier. But I will say that Scott and I had talked about doing this CLE probably a year ago, because we thought there's so many potential issues here for schools, and that schools are seeing and had been seeing even before the change in administration. And those risks, I think, have only increased since then. But that's really our side. Now we're going to talk, or let Brant talk about what's happening with all of the hot topics these days.
All right, but before we get there, Brant, I think we're at our first secret word. So today's first secret word is twilight. Please select the correct word from the choices below. We'll give you guys a full second to do that. I think everyone realizes that was more than a Grants 101. Thank you, Camille. Thank you, Jana, for that. And with each of our secret words, I will list a fun fact about one of our presenters that I solicited prior to the presentation. So first up is Camille. I love Camille's fun fact. So in a past life, she was once a historical archaeologist and participant for a grant to aid in the digitization of archaeological artifacts, and with our education theme, taught middle school for 3 years, all grades. So I love that. Thank you, Camille, for sharing those. Give everyone another minute or two, and then Brant's going to take us through all the noteworthy things with the news. And so let me turn it over to him now.
All right. Thank you, Scott. Good afternoon, everyone, and thank you for tuning in today. My name is Brant Hill, and I'm going to be talking about the recent litigation over the termination of education-related grants. And there has been a lot of it lately. Thousands of grants have been terminated just over the past few months by a number of federal agencies, including grants from the Department of Education and from the National Institutes of Health. And that's really what I'm going to be focusing on today. And virtually all these grants were terminated for the same reason, because of the new administration's position on DEI, diversity, equity, and inclusion. And those terminations have prompted a wave of lawsuits being filed against the government. And until last week, the plaintiffs in all these cases had been overwhelmingly successful in persuading courts to issue immediate injunctive relief and reinstate those grants on a temporary basis until the courts had more time to decide the merits of their claims. But then last Friday, the United States Supreme Court in one of these cases ruled for the government for procedural reasons related to jurisdiction, and we're going to get into that, But the court said basically that the Department of Education could temporarily re-terminate the grants for the time until there was a future decision on the merits. And so today I'm going to walk through these cases, explain how we got to that Supreme Court ruling, and offer some thoughts on where I think all that litigation is headed. But I want to say one more thing before I really dive into it. And that's that all the information that you just heard from Jana, Camille, and Scott is completely accurate. They are grant experts. They know the grant rules and the nuts and bolts of how grants work and how they operate. At the same time, we're really in uncharted territory right now. And I don't think I'm going out on a limb by saying that the normal grant rules are not necessarily being followed by this administration. Grants are being terminated left and right, and the very same types of grants were almost never terminated over the past few decades. So does that mean that if you're a grant recipient, you shouldn't follow the normal rules either? Absolutely not. You should follow them, and we're going to discuss a little bit later what to do if your grant is terminated. But it does mean that if your grant is terminated and you find yourself having to file a lawsuit over a termination, you have to trust that the judicial process will work and that the law will be evenly enforced with no thumb on the scale in favor of the government. And by and large, I think what you'll see is that the judicial process has been working. It's been working at breakneck speed. Courts are working around the clock right now in what is probably the most litigious time in the history of the United States, if not at least the most litigious time in the history of the Department of Education. Now, there certainly was an adverse ruling last week by the United States Supreme Court, but that doesn't mean that the process isn't working. And ultimately, as I'm going to explain, that decision was not a ruling on the merits. It was on technical grounds. And so, while certainly the ruling is probably discouraging for those affected by it, I don't think it's the end of the story here. Litigation is going to continue. And just based on my personal opinion, in the long term, I tend to think that the government is ultimately facing an uphill battle here when it comes to terminating these grants. So let's get into it. I'm first going to talk about the Department of Education's recent termination of teacher grants, which ultimately were the subject of that Supreme Court ruling. And I've listed the grants here on the slides, but generally, these are all grants that the department awards to institutions for them to spend funds to recruit, educate, and train students who will ultimately become teachers. And there's some differences between them, but the important thing for today's purposes is that these grants are all authorized by Congress, and for each of them, at least one of Congress's goals was for the department to fund activities that generally would achieve a benefit that falls under the umbrella term of DEI. So, for example, one of Congress's purposes in creating the Teacher Quality Partnership Grant was to recruit minorities into the teaching force. And with the SEED grant program, one of Congress's goals was to provide pathways for teachers to serve in traditionally underserved communities. Okay, so these grants all have some kind of DEI-related purpose or intended benefit. Now, as you've heard from Camille and Jana, the way that these grants are awarded is that the department invites institutions to apply for them by issuing a formal notice. And the notices say the department will assess applicants based on their ability to meet certain priorities. And these priorities are established by the department when it goes through a notice and comment rulemaking process. So the Department of Education can't just make up these priorities on the fly. It's got to go through that rulemaking process. And so over the last several years, the department under the Biden administration invited schools to apply and awarded over 100 of these teacher grants to schools that met those priorities. And again, some of these priorities were DEI related. And depending on the grant, they are generally for 3 to 5 year periods. So, by and large, everything was going smoothly for the recipients of these teacher grants until President Trump issued a couple executive orders after taking office in January 2025. And these DEI executive orders declared that DEI practices that discriminated based on race, color, or other protected characteristics were illegal. And the executive orders directed that all federal agencies, including the Department of Education, to terminate illegal DEI or equity-related federal grants and contracts. Now, the orders didn't say what illegal DEI meant or what equity-related meant or give any examples of that. And so it triggered this, immediate confusion and concern for grant recipients. How would they know if their grant programs were going to be targeted by the administration? Well, they never really got any clarification on that. And instead, a couple weeks later, in early February of this year, the department terminated virtually all these 100 plus teacher grants. And it did so by sending boilerplate form letters to all these recipients saying their grant programs had been terminated because they funded illegal DEI practices and that they were therefore inconsistent with and no longer effectuated the department's priorities. Well, that ultimately led to a couple lawsuits being filed. One was filed in federal court in Maryland by a few nonprofit organizations. The other was filed in federal court in Massachusetts by a group of 8 states. And in both cases, they were brought on behalf of recipients who had their grants terminated. And the plaintiffs in these cases brought their claims under a federal law called the Administrative Procedure Act, or the APA. And the APA is a federal law that says, among other things, federal agencies cannot make decisions that are arbitrary and capricious. Now, what does that mean? Well, it generally means that an agency's decision has to be reasonable and its decision-making process has to be legitimate. The agency has to explain itself and point to facts and evidence that support its decision. It can't be just a sham. And in these cases, the plaintiffs argue that the department's termination decisions didn't meet that standard. Okay, these were boilerplate letters, not unique to any one individual grant recipient. And they didn't say why any individual school's activities had promoted illegal DEI or otherwise discriminated based on protected characteristics. And so in both cases, the plaintiffs asked courts for immediate injunctive relief to reinstate their grants, at least on just a temporary basis, until the courts had some more time to consider the merits of their claims. And that's a process that usually takes several months, if not longer. And that to get an immediate injunction, plaintiffs generally have to show a couple things. One, that they're at least likely to win on the merits of their claims, but also that they would be irreparably harmed without the injunction. And what irreparable harm means is that if the plaintiff doesn't get that immediate injunction, then it won't matter if they later on win on the merits and get relief down the road, because in the meantime, they're going to suffer permanent consequences that can't be remedied in the future. And so the plaintiffs in these cases said, hey, courts, we're not only right on the merits here, but we'd be irreparably harmed if these grants remain terminated and we lose our funding, because we're ultimately going to have to shut down these teacher programs and lay off some people. Well, in both cases, the district courts ruled for the plaintiffs and reinstated their grants temporarily. That was last month in March. And both courts agreed that the grant recipients would be irreparably harmed. And on the merits, they both agreed that the department's decision was likely arbitrary and capricious and therefore violated the APA. They pointed out, just like the plaintiffs had argued, these were boilerplate letters. There was no individualized analysis of any of the programs. And the department didn't really fight back on the arbitrary and capricious issue. But what's interesting here is that it did argue that it had the discretion to terminate these grants because they no longer effectuated agency priorities. And under the department's regulations, it actually can terminate a grant if it no longer effectuates its priorities. But the court shot down that argument too. And basically what they said is that, hey, department, your priorities are set forth in regulation. They were listed in the notices that invited these grant recipients to apply. And there was no question at all that all these recipients met those priorities. And so the court said to the department, you're free to change your priorities if you don't like the prior administration's priorities, but only if you go through the noticing comment rulemaking process, okay? And you haven't done that here yet. So the courts ordered that these grants be reinstated temporarily. So that was an initial win for the recipients. But then, of course, the department appealed in both these cases. And in both cases, along with the appeal, it also asked the appellate courts to stay those injunctions and just re-terminate the grants just on a temporary basis until the appellate courts had time to decide the appeal on a fuller record. Well, the First Circuit in the case that was brought by the states said no. And so the department then went to the United States Supreme Court and made the same request on an emergency basis. Just let us re-terminate these grants temporarily, and then we can fight about the issue back in the lower courts. Meanwhile, the Fourth Circuit in the other case, the AACTE case, said, let's just wait for the Supreme Court to rule on this issue. Well, this time the department won. Last Friday, the Supreme Court, by a 5-4 majority, ruled for the department and ordered the grants be re-terminated temporarily until the First Circuit ruled on the appeal. And the majority's decision really turned on two issues, neither of which, importantly, go to the merits of the case. The first thing that the majority said is that the district court likely lacked jurisdiction to even hear the plaintiff's claims under the APA in the first place. What does that mean? Well, it means that the Supreme Court didn't think that the plaintiffs had filed their lawsuit in the right court. And this is a pretty technical issue, but try and bear with me. There is a federal law called the Tucker Act. And what the Tucker Act says that is that if you bring a claim against the government seeking money that is owed under a contract with the government, your claim must be brought in the Court of Federal Claims. You cannot bring an APA claim in federal district court. You got to bring it in the Court of Federal Claims, which is a different court. And now the plaintiffs in these cases said, we're not seeking the payment of any specific amount of money owed under a contract. We're just seeking an injunction in the reinstatement of our grants. Well, of course, the recipients do receive money from the government under those grants. And there's a blurry distinction between claims that directly seek money from the government and claims that don't directly seek money, but that seek an injunction and kind of incidentally impact the disbursement of money. And if that sounds confusing, it is because it is confusing. But nevertheless, until this ruling, the case law that had developed over many years had supported the plaintiff's position in this case. And that's what the dissent pointed out. Nevertheless, the majority disagreed. They said that the plaintiffs probably should have sued the department in the Court of Federal Claims, not in federal district court. So that is one part of the ruling. The other part of the ruling that frankly is a little hard to grapple with is the majority's finding that the Department of Education would be irreparably harmed if the grants remained reinstated pending appeal. And the majority said that if these grants remain reinstated, the recipients might go draw down funds that the department might never be able to recoup in the future, even if it ultimately won on the merits. And the critical evidence here that the Supreme Court found important was that certain grant recipients had apparently represented that they had the financial wherewithal to keep their programs running, even if they were terminated. And so the Supreme Court said, to the extent that the recipients declined to keep the programs operating, then any ensuing harm would be of their own making. Now, there certainly was contrary evidence on this point. As the dissent pointed out, there is evidence that the loss of grants would force the recipients to shut down their teacher training programs because they did not have the funds themselves to keep them operating. And moreover, there wasn't even any evidence that any of these recipients had tried to draw down a whole bunch of funds after their grants were initially reinstated by the district courts in March. And in fact, that's not even how funding works under these grants. Generally, recipients only draw down funds after they incur expenses and then seek reimbursement from the government. But ultimately, that didn't matter to the majority. And just trying to read the tea leaves here, it seems that the fact that a few select grant recipients out of the 100 plus, the fact that those few did have funds to keep operating their programs ultimately carried the day, even though the overwhelming majority of recipients didn't have those funds. So what happens next? Well, the teacher grants in that case are re-terminated for now. The case will go back to the First Circuit to rule on the appeal, and eventually it could come back to the Supreme Court. As for the AACTE case, which is a distinct case, but involved the same issue, it was technically not impacted by the Supreme Court's ruling. It's a different case. But then just yesterday, the Fourth Circuit issued a one-paragraph order that also granted the department's request for a stay, essentially re-terminating the teacher grants at issue in that case as well. So in the short term, what could happen now? There's a couple things. First, the plaintiffs could go back to the lower courts and fight over whether the district court had jurisdiction, which the Supreme Court suggested it didn't have, but didn't ultimately rule on definitively. Or instead, the plaintiffs could accept that the district court didn't have jurisdiction and then essentially transfer the case to the Court of Federal Claims, kind of start the process over again. Based on a filing this week, in one of these two cases, my understanding is that the plaintiffs are going to fight the jurisdictional issue, and so litigation is going to continue, at least for now, in the lower courts, not in the Court of Federal Claims. So that is where we are on the teacher grant cases. Again, the core merits issues have not been definitively decided. The litigation is going to continue on. It just may end up being that these cases are heard in the Court of Federal Claims. Now, switching gears here a little bit, there is a whole separate category of litigation over a different type of educational grant that has been terminated recently, and specifically research grants awarded by NIH, which is an agency within the Department of Health and Human Services. And every year, as many of you probably know, the NIH awards tens of thousands of grants to researchers at universities across the countries. And among the many topics that Congress directed NIH to fund is to research into health equity and health disparities across diverse populations. Well, in late February 2025, the NIH suddenly terminated hundreds of these research grants. And just like the department did in the teacher grant cases, the agency here sent boilerplate letters that said the grants were terminated because they no longer effectuated agency priorities and were connected to DEI, as well as other controversial topics like transgender issues, COVID, and China, and so forth. And so a couple lawsuits have been filed in federal court in Massachusetts, one by individual research organizations, another by a group of states. And their claims and arguments generally largely track those that were made in the teacher grant cases. And the underlying issues are really pretty similar. For example, the same question over jurisdiction and whether the Court of Federal Claims is the proper court to hear the case is being tested. So the Supreme Court's ruling in the teacher grant case certainly is going to have an impact here, and it may end up being that these NIH research grant cases also go to the Court of Federal Claims. We're just going to have to see. But also, just like with the teacher grant cases, where Congress had directed the department to award grants to schools that would achieve some DEI-related purpose, Congress here directed the NIH to fund research into topics that the new administration finds objectionable. And so you have a situation where, the executive branch is trying to withhold appropriated funds based on new policy reasons that directly conflict with the intent of Congress. Now, Congress, under the Constitution, has the power of the purse, and federal agencies cannot refuse to spend funds that Congress has directed it to spend. And so this case, like the teacher grant cases, really sets up a constitutional battle over the scope of the executive branch's authority. And that's exactly what the plaintiffs in these cases argue. They argue that the terminations of their grants cut across diverse topics that NIH is statutorily required to research. So again, very similar issues in these NIH cases, but one unique argument that the plaintiffs have in these cases that goes to the merits is that, unlike the Department of Education, the NIH doesn't even have the authority to terminate a grant on the basis that it doesn't effectuate the agency's priorities. Instead, NIH is limited to terminating grants for a few specific reasons. One, if the grantee fails to comply with the terms and conditions of the award. Two, for cause. Or three, with the consent of the grantee. Okay, but not on the basis that the grant doesn't effectuate agency priorities. And so here, there's even a stronger argument that NIH's termination of these research grants for DEI-related reasons was unlawful. Now, finally, I do want to mention the funding issues that are facing Columbia University, and certainly not just Columbia, other schools too, but there's already been some litigation involving Columbia, and so I want to focus on this really quickly. In early March of this year, a variety of federal agencies announced the immediate cancellation of $400 million in federal grants and contracts to Columbia University due to the school's continued inaction in the face of persistent harassment of Jewish students. Okay, and that's a reference to the protests at Columbia and at many other campuses in the wake of the October 2023 Hamas attack in Israel. And the department claimed that Columbia's alleged inaction in response to those protests violated Title VI of the Civil Rights Act. And that's the law that prohibits federal fund recipients from discriminating on the basis of race, color, and national origin. Now, the government, since that early March announcement, has since entered into negotiations with Columbia to try and resolve the matter. And Columbia initially gave in to some of the government's demands, but the dispute is still ongoing, and the grants remain terminated. I just saw this morning that there's a report that the government is considering entering into a consent decree with Columbia. We'll have to see where that goes. But at least as of now, the grants remain terminated. And so a couple weeks ago, a lawsuit was filed by organizations on behalf of Columbia researchers. And again, the plaintiffs make many of the same arguments as in all the other cases that I've talked about. They also argue that the government is violating the First Amendment. Okay? Essentially, that the government is unlawfully conditioning funding on Columbia adopting the government's position on political issues, which violates their freedom of speech rights. They do have one more unique argument in this case, And that is that because these grants were terminated because of Columbia's alleged violation of Title VI, the department was required to follow a very specific process before it was allowed to formally terminate these grants, and that it failed to do so. And for example, there are notice and hearing requirements, and they argue that none of these requirements were met. So a motion for preliminary injunction was filed just a few days ago in this case, seeking to reinstate the grants, and that is where we are with that case. And so just as a final takeaway with all this, these cases may end up in the Federal Court of Federal Claims, but the important thing for right now is that all this litigation is far from over, and the Supreme Court's ruling of the teacher grant case, while certainly a win for the government, it's a relatively limited win. It's a procedural win, but it's not a win on the merits. And so there's a lot left to be said here. And so with that, I will pass it back to Scott. I think we have another secret word.
You're right, Brent. Thank you very much. Today's second secret word of the day is warm. Please select the correct word from the choices below. I'll also address one of our non-substantive questions. Yes, there will be recordings. They are on YouTube. They'll be sent out in the higher education resources. You can see all of our webinars on demand. They are free to go. I know we have a lot to get to. We're going to go through it at a brisk pace. I want to give everyone a chance to respond to the question and give you some fun facts about Jana. So Jana is the vice chair of the ABA Public Contract Law Section, Public Contract Law Section's Grants Law Committee. And she also teaches government contracts claims at my alma mater, the George Washington University Law School, and she helped JD and LLM students understand all of these fun nuances. What a time to be learning this for the first time. And with that, I'm actually not picking up with the next one, so I'll just hit next, and whoever's there can jump in.
All right, I think that's me. And really here, what I wanted to just kind of tie back to from Brandt's discussion, back to what we were talking about earlier and what we're seeing and how things are playing out. As Brandt mentioned, there's a fair bit of litigation happening about terminations right now. These are really on the right-hand side of this matrix here. But there's a lot of other things that we're seeing happening with grants. And so we referenced this a little bit as well. So we're seeing agencies just not paying grants. There's cost reimbursement requests that have been outstanding since January. So at this point, there are institutions that may have been floating costs for 4 months. And these are grants that have not been terminated, but they're just not getting paid out. So that's, I think, what I would consider an adverse agency action that institutions are probably, or should be at least, thinking about how to address. We've also seen the unilateral changes to awards that, one example is the NIH change on the indirect cost rate. So there's a lot of things that are happening, not just terminations, but the terminations are something that I think are getting a lot of press and attention and attention from attorneys. I do think, in all honesty, it's really hard to lump all of them together as well. I do think in many instances, the government has an uphill battle, but in many instances, I don't know that it does. I think there's going to be a lot of instances where the government will prevail in its ability to terminate these awards. And I say that because I do think for institutions right now, it's going to be really important for you all to have an understanding of which ones are likely to maybe have some success, and as far as litigation goes, and which ones aren't. Because if you're losing the grant funding, you don't want to spend money on litigation if it's going to go away for one reason or another. And I think some of the grant awards that we've seen terminated, when the agency gives 6 reasons for terminating the award, they only have to succeed on 1 to be able to terminate the award. So even if they weren't able to terminate it because of a change in priorities, they may be able to terminate it here in the bottom right corner for another reason. And if they can do that, you may win on the merits for your argument of whether or not they could terminate for that reason, but you're not keeping the award. And so to me, that's a real everyday risks that institutions need to be thinking about when they're considering when to challenge terminations and what terminations they want to challenge if they go to court. And I also think it's one of those things that whenever you look at school specific terminations, so where we're seeing schools having a lot or all of their grants terminated, that to me is also a very different situation than when you're looking at programs being terminated across the board, because there's very different arguments that can be made. And this plays a bit into what we're seeing, as far as how to respond as well. Because really what schools need to be doing once they get some kind of adverse agency action, whether it's the non-payment, the unilateral change, or some termination, you've got to assess what's happening. You need to look at what's the basis for the action, what's the impact on the school. I think, to me, the impact question was really relevant in one of the cases Brent was talking about, from the perspective of if the school can keep paying for the grants, it's really hard to justify from a court perspective what the harm is to the school. And that's going to be something I think the school needs to be thinking about as well when they're looking at these questions. But also then determine whether the response or an administrative appeal is needed or desired. And you're going to look at a number of different things when you do that. And then you may lodge an administrative appeal. Brent's in a minute going to talk about how litigation may play out. But I think there's a number of different other things that schools are starting to consider too, beyond just responding to the agency or addressing litigation. One of the things we're seeing is a lot of lobbying happening. We're hearing from folks on the Hill that they are getting calls from their schools that they've never heard of. Our lobbying team would say that's a huge issue, that schools should have been having relationships with their representatives for a long time. But that is something we are seeing a ton of now in the DC area. Is there's a lot more outreach and a lot more looks at relationship building with folks on the Hill and with folks who are at funding or at the committees that relate to various funding. And I'll be honest, I've even seen one university buy out an entire metro station right by the Capitol building because they are looking at getting the attention of their representatives. So these are things that we're starting to see that schools are doing because it's important. And as Brandt's going to talk about, there's the questions about how to deal with this if you do want to appeal. But as Camille and I have experienced at the Court of Federal Claims, it is not the same place as being a district court. There are a ton of differences. I could bore you with the history. My husband wrote an article for the Federal Circuit's Historical Society on the history of the Court of Federal Claims and the Federal Circuit, which is the appellate level court for the Court of Federal Claims. It is a court that came out of cotton claimants from the Civil War, and so that Congress didn't have to appropriate money for people who were injured by government action. It is not the same kind of place that you would see in district court. There's very different rules. The judges, it's an Article 1 court, not an Article 3. There's a lot of things to consider as you look at how to address these things, which I know Brandt's going to do.
Thanks, Jana. And yeah, I'm going to go quickly here because I know we're up against it and I want to leave time for questions. But one topic that frequently comes up is, whether or not recipients have to appeal their terminations, or they can just go ahead and file a lawsuit in federal court. And the answer is generally yes, you do need to appeal. And the reason is because, okay, I'm move back a slide. Okay. And the reason that you need to file that appeal is because there's a legal doctrine called the exhaustion of administrative remedies. And what it means is basically that before you can file a lawsuit in court against a federal government agency, you first have to seek relief through that agency's administrative relief process. And the idea is that some disputes can probably be resolved through that appeals process. And courts want to give agencies a second chance to review the matter before the courts get flooded with a whole bunch of lawsuits. Now, there's a couple exceptions to that doctrine. First, where the agency doesn't have an appeal process at all. But second, where the appeal process would be futile. And the futility exception applies if it's almost certain that the agency isn't going to change its mind on an appeal. And that exception would very likely apply right now to all these grants being terminated for DEI reasons, given that there's almost no reason to believe that the agency is going to change their mind on appeal, right? Nevertheless, I think everyone speaking here today would still highly recommend that recipients whose grants are terminated file the appeal, follow the normal appeal procedures. And on the screen there's a hyperlink to the normal appeal procedures for the type of Department of Education grants that we've talked about today. You can ultimately still file that lawsuit, but you should still file the appeal just to make sure you don't have to fight an exhaustion argument down the road. Now, I do want to just kind of quickly touch on one other issue, and that's and really return to something that I talked about earlier. And that's federal grants federal grant programs in which Congress either required grant recipients to spend funds in ways that benefit certain minority groups, or at least permits them to do so. And if an agency terminates those grants because they are DEI related, that's directly contrary to the statute. And again, it sets up this constitutional battle over the authority of the executive branch versus the authority of the legislative branch. And so there's a really deeper issue that goes to the core of the Constitution's separation of powers. But in the meantime, it puts these grant recipients in a catch-22. If they don't spend funds as required by Congress and as required by the terms of the grant award, in the hopes that they will avoid being targeted by this administration, they also risk being sued by the intended beneficiaries of those grants. Okay, they may argue that, hey, the recipient's not carrying out this program as Congress intended. They're not complying with its grant award. And so it puts recipients in almost an impossible situation. And so the question is, should you now stop operating your grant program in a way that is DEI related just to stay under the government's radar? That's a question that is challenging, and I advise every grant recipient to seek advice on from your counsel. But I will say this, from what I have seen at least, agencies have been terminating grants based on language in their grant documents and grant applications that those agencies already have. For example, in one of the teacher grant cases, there was evidence that the department had identified grants to terminate by searching for certain language in the grant applications. Okay, the court said that the department's only basis for terminating which grants to terminate was a narrative associated with the grant that included the terms diversity, equity action plan, and DEI. And so if there's a reference to one of these controversial terms that is already out there, what you do today might not even matter. And ultimately, what is critical here is that for all grant recipients, you closely look at the statute that authorized your grant in the terms of your grant award and determine whether it affirmatively requires you to spend funds for a DEI purpose or merely allows you or encourages you to do so. And if it's required, then I would say keep doing it. But if it's merely encouraged and permitted but not required, then you may want to reconsider for the time being. But again, it's a challenging question, and I would advise you certainly to work with your counsel on that question. I've got a case here that I was going to talk about, but we've just got a couple minutes, so I'm going to send it back to Scott, see if he has any final words, and then maybe we can get some questions.
Sounds great, Brant. So just a few thoughts on in-house counsel, and then we're going to get to questions, I promise. So if you have any, put them in the chat now, right? So for your existing grants, just what I would do if I was in-house counsel right now, inventory what you have, understand the scope of language, right, that Brant talked about. Is it mandatory? Is it permissive? Review your grant processes, right? Understand, as Camille was saying, what do you have? Where does it go? Where's your internal control? and consider adjusting as needed, right? A lot of schools are taking a look at this and consider whether this should be led by attorneys and not just responded to by attorneys, right? Not only does that impact privilege issues, but also, as Jana pointed out, getting involved in the proposal stage is really important. By the time you hit the award stage, counsel and kind of the legal pieces might, the horse already would have left the barn, if that's the right metaphor. All right, so important to review termination language and the processes and procedures relating to grants, right? Are we under Department of Ed procedures and 2 CFR Part 200? Is it NIH? Important to kind of understand both the administrative processes and what's actually in the grants, and do that risk assessment, right? As Brant was talking about, if you have a potential grant that's kind of on the line there, talk to counsel, understand where your risks are, understand that if it's a challenge, right? If we think this is going to be potentially shut down by the government, that's an important consideration as well. And with that, I'm going to bring us to our third secret word. We're going to take questions right after this, I think. Maybe one more slide is dandelion. Choose the correct word from the choices below. I'm going to finish out with our friend Brant here and his fun facts. So Brant is a former college Division I baseball player. Sadly for Brant, his playing days were too long ago to make him eligible for a house settlement. I'm sorry, Brant. I know you're looking forward to that, but not in the cards there. And also, interestingly, he's a gardener, which I love that as well. So D1 baseball player, gardener, and Brant's having elbow surgery soon, but I'm going to make him play on my rec team when he recovers. Last slide. So future grants, right? We talked about the past ones. Be involved in the assessment, right? At the beginning, we talked about, think about the process, think about things you want to change in the process. Legal review and approval for signing any grant documents, right? Regardless of the stage they're at. If your school continues to seek federal grants, consider whether the grants team has sufficient support, right? Do that in controlled assessment. Make sure that, I mean, this is a fraught issue. Make sure that we're setting everyone up for success. Really quickly, extra credit. For those of you going to NACUA, we'd love to see you. We're having a great event. Our partner, Bill Bay, who's also the president of the ABA, is giving the opening plenary address. We have a lot of speakers. We have a great event at a cool rooftop. Please join us. We'd love to see you or your colleagues going to NACUA Seattle in November. All these compliance materials are that magic QR code. Please feel free to use them. We have a great blog. We talk about all higher education issues all the time. Please check it out if you're interested. This webinar, along with all our others, will be in our YouTube page. If you have any questions, right, about TCPA, Brant and Trey did that before, Title VI, gainful employment, all the other fun stuff we're doing. Same magic QR code. And a final condition of use and disclaimer, we're not your lawyers unless we are your lawyers. So give us a call if you have any questions on this. Jana, let me address the first question to you, right? So this is from one of our friends out west. So during a pre-award compliance check, an agency is asking the institution to certify compliance with EO 11246. But how can they do that or expect that when EO 11246 was revoked?
So I'll start by saying what this question brings up is something we're seeing across the board with the DEI kind of certifications generally, which is that it is all over the board. There is not consensus within the federal government of how to address this. And I say federal government because it differs from agency to agency. It differs from department within an agency. It even differs from the agreements officers or contracting officers if you have government contracts and not just federal grants. There are certifications that are being asked that are different all over the place. And I say that because, as Scott was pointing out at the beginning, some of you have very large institutions that are dispersed, and there may be these certification requests coming in from various areas. You may be getting them pre-award, like the question indicated, or you could be getting them for some of your current awards. The key thing, I think, is to make sure that you understand what you're certifying to. And this is why I think it's really important for general counsel and C-suite folks to understand why this is, or how this is all happening, because you don't want anyone making these certifications without you looking at it. Any of these certifications can give rise to False Claims Act issues. And I say False Claims Act, for those of you who aren't familiar with it, it could be 3 times the amount of your award plus penalties for every invoice you submit. This is not something you should sign unless you understand what it means. And I say what it means. I know that's not answering your question from the audience of how can they request this or expect that certification. You still have to respond. It's something they probably shouldn't be asking given the revocation of EO 11246, which for those of you who aren't familiar, it's the executive order from President Biden, or I'm sorry, not President Biden, from President Johnson, I think.
Johnson, yeah.
Yes, from 50 years ago, from the 60s. I can't do math. From the 60s, related to affirmative action under federal awards. It's something that shouldn't be asked right now, but it is. And it's also something we're hearing. There's some agreements officers telling folks not to comply with it. There's some agreements officers telling folks to comply with it. So you're hearing things all over the board. This is something that especially you want to address with counsel who understands the EO 11246 implications and your awards, because what you're certifying and what you're doing are things that are going to play into the risks that the institution has.
Hey, Jana, for future awards, is this, and I don't know the answer to this question, I'll put you on the spot a little bit, but is this something that, as Camille's saying, could be negotiated, right? If you see something like this to work it through, or is this a condition that's probably going to be written in stone?
I would say it's if the agency is raising this pre-award, it's certainly something that can be addressed through negotiation and just say we're not going to answer it. However, it's really hard to do that at the pre-award compliance check where they are just asking you to provide responses and you're going to be given a thumbs up or thumbs down. And so usually you're going to want to craft a very well drafted response as to what you have been doing for compliance and why you are or are not certifying compliance with that.
Interesting. Yeah, it seems like one of those, you might have to talk to your lawyer about it. We're over time, but we have only a couple questions left. So I think we're going to try and stick around to answer them. And hopefully you guys can as well. Jana, maybe this one for you and Camille. Can an institution have a different set of policies for private grants versus federal grants?
And I can hop in, and Camille, if you want to correct me on anything I say, definitely do so. But yes and no. So there's some of these that you could have different policies for, some that you would not be able to have different policies for. One that sticks out in particular where you cannot have different policies is your timekeeping. And that's where things start to get very tricky for the institutions because you can't have a faculty member that is keeping their time under the federal requirements for their federal awards under one policy and then using a different policy for privately funded awards. That's going to be a huge issue. That's the kind of thing that could certainly cause a problem in audits, but also just from a compliance review or potentially into the False Claims Act area, depending on how the timekeeping policies differ. And that's something that even comes into play for folks who are doing indirect costs. So any administrative folks you have that are tracking their time, you don't want that to differ for federal versus privately funded grants. So yes and no, there might be some policies that you could have that are different, such as your research policies and what's required for research conduct. But that's, I think it's going to be a case-by-case basis on policies. Yikes.
Sounds like a lot. Camille, any other thoughts or Jana hit it all, you think?
Yeah, Jana hit it all. It's difficult to sort of balance having private and federal policies. So really, I guess, trying to combine them as much as possible because you don't want to also confuse the people who are going to actually be following them, like your employees and so forth. So you want to make sure that everyone's on the same page. So having as much consistency among the policies is going to be key there.
Great thought, and yeah, very helpful advice. And it sounds like this is a great question and one that you two have probably addressed before. So we'll keep it there. And Brant, I'm going to put you on the spot for the last one. If you're willing, I think we're getting over. I don't want to keep people too long on a Friday. Brant, if a school has a status like HSI, Hispanic Supporting Institution, or MSI, Minority Supporting Institution, is that status alone, or is that status contributing potentially to losing grants just based on the status?
Yeah, this is a question that would have almost been unimaginable a few years ago, but we're obviously in a very different environment right now. HSIs receive grants under programs that are authorized by Congress, and Congress, requires that a condition of these grants, HSIs have a certain minimum percentage of their student body being comprised of Hispanic students. And if the Department of Education were to take action against an HSI because of the fact that it has that it provides preferences for Hispanics, I mean, that would be clearly contrary to Congress's intent, and again set up that constitutional battle over the power of the executive branch versus the power of the legislative branch. But it really, if that challenge were to play out, what would happen is that there would ultimately be a question over whether that law that Congress passed that distinguishes between people based on different races and colors and ethnicities, whether that law violates the Equal Protection Clause. And a law that discriminates or distinguishes between people based on race will violate the Equal Protection Clause unless that law satisfies a test called strict scrutiny. And basically the question is, does the law serve a compelling government interest, and is the law narrowly tailored to achieve that purpose? I think with just generally in this situation, I think there are very good arguments that that law would meet that test. Although it's a very difficult test to meet, I do think it would be met. Now, at the same time, with the current Supreme Court and especially the Students for Fair Admission decision, it could be challenging. There's really just there's no clear answer here on whether the Supreme Court would uphold the law like that. But that issue is really at the core of kind of everything that we're talking about in the current environment and DEI. So that was a bit of a mouthful, but that's what I would say. I don't know if anybody else has anything to add.
Man, I feel like every issue here in these past couple of weeks has been a mouthful. I think I'm gonna call it a presentation. We're going over, and we're probably at risk of getting kicked off the platform. So let me just say thank you to Camille and Jana and Brant for your expertise and kind of wading through this, and hopefully we can have some certainty and kind of not have to review this every couple of days. But I feel like that's the path we're going to. Thank you to everyone for sticking with us. I know we had the technical difficulties. Now we're back here on Friday afternoon from the East Coast. So thank you guys for tuning in. Thank you for everything you're doing for higher education. It's a challenging time to be a higher ed administrator. So we appreciate everything there. If you have any questions, please, our emails are in the chat, are in the presentation. Please download it. Please reach out to us. We're here to help, and hope everyone has a great weekend.
Hey, thanks, y'all.